don't recognize lawful people very easily anymore.
Well, yeah, but by doing that, it's unlawful to do that because we're flesh and blood and the patent is forever.
Right. So if I read the question again, does treaty law and constitutionally secured rights fall under federal jurisdiction? If you look at things like 18 U.S.C. 2071 for concealing the public record or destruction or alteration of public records, or if you look at 18 U.S.C. 241 and 242, which is deprivation of rights under color of law. If you look under 18 U.S.C. 245, which is federally protected activities, you'll see that treaty law and constitutionality is under federal jurisdiction. There is some honor in the United States Code.
Yes.
But there is confusion about who gets the relief or the protection from it.
Well, let me give you another one that you might want to put in your response there to these people. If you go to Title 43, Section 57 and 83, it states that any certified copy of a land patent can be brought to any court in all courts in the United States. Now, here's where these lower court rulings have got a real problem, because they're bound by the Constitution to protect that land patent. And that's what the Title 43, Sections 57 and 83 identify. And it says the courts must, you have to look at the language, must means mandatory, take judicial notice of its evidentiary effect. Now, boy, that's powerful as hell, simply because they cannot denounce, they cannot reduce, they cannot alter that patent.
Comes from a higher jurisdiction in a forever contract.
That's correct. It is a contract, and the United States government, because they're the grantee, has to honor that and they have to protect it. That's the purpose. If you go back to Summa Corporation, they addressed that issue. That is a contract. That's also in Fletcher versus Peck and many other court cases. But the very fact that that patent is forever. If it was not, then the Supreme Court in the Summa Corporation versus State of California, 1984,